welcome to Tarun. Today we will be discussing editorial from The Hindu and Indian Express. So I have taken this editorial from Indian Express, Principle of Seniority and next DY Chandrchud's 5+1 Collegium. We will discuss what is Collegium system and what is the principle of seniority that is followed in the Collegium system, and what is this 5+1 Collegium system. This is from the explained page from the Indian Express. However, I have taken another editorial from The Hindu of 13th of October 2022. This is from 12th of October Indian Express, and this editorial is from 13th of October from The Hindu. The quote and the problem with its Collegium. The writer has pointed to few of the problems that Collegium system has, and we will see what those problems are. But before that, we will look at what Collegium system is and how the appointment of judges is done in India. Now, the topic is the Chief Justice of India and the appointment, and the context is that the current CGI Chief Justice of India, UU Lalit, he has recommended Justice DY Chandrchud as his successor. So we will see, and this has been done in following the convention of seniority. You can relate this topic from your General Studies paper 2. Now let's see how the judges are appointed in India. The constitutional provision related to the appointment of judges is Article 124, which says that the President, in consultation with the Chief Justice of India, would appoint judges of Supreme Court and High Court as the President deems necessary, and the other judges are appointed by the President in consulting with the CGI and other Supreme Court and High Court judges. The Article 217 is related with the High Court. It says that the President, after consultation with the CGI and the Governor of the state concerned, would be appointing the Chief Justice of the High Court, and the other judges of the High Court are also appointed by the President after consultation with the Chief Justice of India and the Governor of the state and Chief Justice of the concerned state. So if I draw a flow chart, then this would be like this. For example, this is Supreme Court and this is High Court. So the judges of the Supreme Court, we have Chief Justice of India and we have got other judges. Now this is dealt in Article 124 Clause 2, and this is dealt in Article 217. So here we will have Chief Justice of the High Court and the other judges. Now the Chief Justice of High Court will be appointed by the President in consultation with the Chief Justice of India, Governor of the state, right? So this is done through the Collegium system, and the other judges are also appointed through the Collegium system by President. Chief Justice, the other judges are Chief Justice of the High Court and the Governor. So this is how the appointment in the High Court is done. Now let's see the appointment of the Supreme Court. The Chief Justice of India, the outgoing Chief Justice of India appoints, or not appoint, but recommends his or her successor. For example, the Chief Justice of India, UU Lalit, he has recommended Justice DY Chandrchud as his successor, and other judges are appointed by the President in consultation with the CGI and the 4 senior most judges of the Supreme Court, and this is known as the Collegium. This is the Collegium. All right. So we saw the constitutional provisions which are related to the appointment of the judges, and we also saw how the Collegium is formed when it comes to the appointment of the Supreme Court and when it comes to the appointment of the High Court. Now we will see the procedure which is followed with respect to the recommendation and the appointment of the judges. But before that, let's see the other criteria for the appointment, to be appointed as the judges in the Supreme Court and the High Court. Let's see if I have some space. Okay. Now for the Supreme Court judges, the first criteria is that he or she should be the citizen of India. And second criteria is that he or she should have been a judge of a high court, one or more high court in successive years for 5 years, right? Or they can also, and the third criteria is they can also be the eminent jurist. That means they can be appointed from the bar also. The people from the bar can also be elevated to the Supreme Court as the judges. So eminent jurist. So this is these three criteria are followed when it comes to the appointment of the Supreme Court. All right. Now the Supreme Court judges, their tenure is till the age of 65 years. All right. Now let's see the criteria for the High Court judges. Now when it comes to the High Court judges, there are two most important criteria. The first one is of course the citizen of India, and the second criteria is advocate in any of the high courts for 10 years, for 10 or more years. This is the two criteria which is followed, and they are appointed till the age of 62 years. All right. Now let's see what procedure is followed. Now what happens, let's take this illustration. This is for example, the current CGI, UU Lalit. He would be asked by the Ministry of Law and Justice, he would be asked for his recommendation for his successor, right? And he will send the recommendation to the Ministry of Law and Justice for the next CGI, all right. Now in case of the other judges, a list of judges, the name of the judges who will be elevated either from the bar or from the High Court to the Supreme Court. So the list of those judges will then be sent to the Ministry of Law and Justice. Now what will happen, the name of these judges, or the future judges, it will also go under scrutiny by the Intelligence Bureau, etc. All right. And after all this has been done, the Ministry of Law and Justice would send this recommendation to the Prime Minister. And then as you know that Article 74 says that the President would act on aid and advice of the Council of Ministers. Therefore, the Council of Ministers, in fact, would recommend the President, and the President would then appoint the Chief Justice of India or other judges. We are not going to talk in this article about the appointment of the district judges. We are restricting ourselves to the appointment of Supreme Court and High Court judges. So this is the procedure which is followed. Now let's move on to what is this collegium system that we are talking again and again. So we'll see what this collegium system is. Basically, the collegium system is not mentioned in the Constitution of India. Only two articles with respect to the appointment of the Supreme Court and High Court judges says that the President shall appoint the Chief Justice of India and the other judges in consultation. Now this word, in consultation, has been into controversy. And therefore, it was because of the ambiguity of this word in consultation which led to the collegium system. Collegium system, though it is not mentioned in the Constitution of India, it has evolved over the years. So basically, in the collegium system means there will be a group of judges headed by, if I am to define collegium system, it will be group of judges headed by Chief Justice of India to recommend to the President for the appointment to the judiciary. So this is how we can define the collegium system, though there is no such definition as it has not been mentioned in the Constitution. So the Article 124 and Article 217 only deals with who is going to appoint the Supreme Court and High Court judges. It does not mention the whole procedure that is to be followed. Now, this collegium system, since I said that it has evolved over the years, it has evolved over the years through the three significant verdicts of the Supreme Court, the first, second and the third judges case. Now these three cases and the fourth case also we will discuss, which is the National Judicial Appointment Commission, the NJAC case of the 2014. We will discuss it later on, but right now we are restricting ourselves to these three judges cases, the first, second and the third judges cases. So let's see these three cases one by one, and then we will see how this collegium system has evolved. Now basically, in these judges cases, the collegium system headed by the Chief Justice of India has been given the primacy over the executive. Now this is also in congruence with the Article 50, which says the separation of the executive from the judiciary of the directive principles of the state policy, that is DPSP. So now let's move on to the three judges case. Now how these judges case led to the collegium system. Now in the first judges case of the 1971, which is also known as the SP Gupta versus Union of India. Now in this, what happens? This word consultation was brought to the court. This consultation, it was in the controversy. Now what happened? The Supreme Court ruled that the government can disagree with the CGI for the cogent reason. That means for some significant reason, and the seven judge bench gave the executive the last word on the appointment of the judges. Now what happens? This consultation was interpreted as the recommendation. This consultation was interpreted as recommendation, that the CGI would recommend to the Chief Justice, the Chief Justice of India would recommend to the President with respect to the appointment of Supreme Court and High Court cases. However, in the second judge case of 1993, which is Advocate on Record case versus the Union of India, it's the 9-judge bench. Now, in order to overrule the previous judgment, a bench has to be larger than the previous bench. Therefore, a 7-judge bench in case of the 1983 SP Gupta case had to be overruled by a larger bench. Therefore, a 9-judge bench was formed, which examined the correctness of the 1981 case, that is the SP Gupta case, and the Supreme Court gave two verdicts in this. The first, that the word consultation actually means the congruence. That means the recommendation of the CGI has to be congruent with the appointment done by the President of India, right? Basically, the second judge case gave primacy to the recommendation by the Chief Justice of India. Therefore, judiciary was given primacy. And also what this judgment led to, that there will be a CGI and two senior most judges. So a group was formed. That means a collegium was formed. It was not just the CGI. It was the congruence of the opinion of the two senior most judges of the Supreme Court, who will give recommendation to the President when it comes to appointment of Supreme Court judges or the High Court judges, right? Therefore, this word consultation meant congruence. Earlier it was only recommendatory in nature and executive was given the last word. However, in the second judge case, the Supreme Court overruled its 1981 judgment, and it said that the CGI in consultation, along with two senior most judges, will give recommendation to the President. Now, in reference made by the President K.R. Narayan, the SC reiterated its 1993 judgment. That means the Supreme Court wanted to uphold its independence as well as separation from the executive interference. So therefore, what Supreme Court did, that first thing, it reiterated its 1993 judgment, and the second thing it did, it enlarged the collegium system. That means instead of the two senior most judges, now there are to be 4 senior most judges. So therefore, they increased the strength from 3 to 5. That means the 4 senior most, the collegium headed by the Chief Justice of India. So now we have the Chief Justice of India and the 4 senior most judges of the court. 4 senior most judges of the court. So there they form the 5-member collegium. All right. So now you can see that from first judge's case, second and third judge case evolved a collegium system which finally had the final say when it comes to appointment of the judges in the court. All right. Now let us move on to see that how all are in the collegium system. Now, since the outgoing Chief Justice of India has given just the name of his successor, so we will see that who all will be in the collegium system. Now, this is what we have discussed, that there are 5 members in the collegium system. Now, one of this member is a potential candidate for the post of Chief Justice of India. In case any of the member of the collegium is not the senior-most judge of the Supreme Court, which according to the convention of the seniority is to be appointed as the next CGI, he or she has to be invariably part of this collegium. This led to the formation of the 5+1 collegium when it comes to the tenure of the Justice DY Chandrchud. Now, after the retirement of UU Lalit, if Justice DY Chandrchud is to become the next CGI, he is going to have 5+1. He is going to have 5+1 collegium. All right. So this we discussed that who is going to be in the collegium. Now let's see the purpose of the collegium. Basically, the collegium serves 2 purposes. To have the best possible opinion and to have the best available talent. This we already discussed, that how it is going to be a 5+1 collegium, because if you see that the potential CGI will enter the CGI collegium in the May 2023. However, Justice Khanna, who is going to be 6th member of the collegium, will assume office from 9th November 2023. All right. Now let's see the problems in the collegium. The first problem that was pointed when it comes to the lacunas in the collegium is that it was against the view of the Constituent Assembly. The Constituent Assembly was of the opinion that the Chief Justice of India cannot be granted the veto power when it comes to the appointment, and he cannot be granted, he or she cannot be granted this unfettered power when it comes to the appointment. And the collegium system, it is often accused of being autocratic. There is no transparency. That means the collegium system is opaque. The reason for the appointment of a judge and reason for the removal, transfer of a judge, which is also done by the collegium, they are not given in the public domain. The judiciary has their own reason when it comes to the opaqueness. The merit versus seniority. You know that in the collegium systems, the convention or principle of seniority is followed, which is often said that it is against the merit. For example, if there is more meritorious judge, but he or she is not the senior most judge, so still are we going to follow the principle of seniority or the merit? So this is the question that comes. There is no system of check and balance. For example, if we take the 4th judge case now, the 4th judge case of 2014, which is the NJAC case, which is National Judicial Appointment Commission. Now, this was the 99th Constitutional Amendment Act, which was passed by the Parliament of India to have a commission for the appointment of the judges. But what happened in the 4th judge case? The judiciary, that is Supreme Court, struck it down by saying that it basically is the interference by the executive, and it will reduce the independence of the court, and it will also go against the constitution provision of Article 50 of DPSPs, which says the separation of judiciary from the executive. There are vacancies in the court. Now, so far collegium system has failed to fill the vacancies in the court. For example, in the High Court, and there are vacancies which are to be filled in the Supreme Court, and hopefully it will be done by the Collegium of Justice DY Chandrchud. Now, the Law Commission in its 230th report said the Collegium, it works on nepotism. It also said the Collegium is violation of the Article 74, which says that the President shall work according to the aid and advice of the Council of Ministers. So these are the problems in the Collegium. These are the general problems in the Collegium. Now let's see this particular editorial from the Hindu. So the writer who is the advocate in the Supreme Court says that the short tenure of the current CGI, the tenure of the of Chief Justice of India UU Lalit, it's very short. So the tenure of a Chief Justice of India, because of the problem of until 65 years. So this is the problem here. So the Chief Justice of India, they often have very short tenure. Justice DY Chandrchud is going to have a 2-year tenure if he is appointed as Chief Justice of India. So short tenure of the CGI is the problem. In such a short span of tenure, a CGI cannot work efficiently and sufficiently to fill all the gaps in the judiciary. The question arising due to the memorandum of procedure. Now when it comes to the appointment, a CGI is to take the opinion of the 4 senior-most judges. Now here in this particular case that the writer appoints, that 2 of the senior-most judges, they basically did not give their opinion via circulation, as there were no meeting held for the recommendation. Other lacunar system was pointed by the writer is the struck down of the NJAC. This is against the principle of natural justice, that you are judge in your own case. So this is what the writer says. The appointment, it says that it has become the preserve of the judges, and executive and legislature, they have no say in it. So this is the problem that the writer points out in this article. I have taken only the important points here. I have only taken the important points from this particular editorial that appeared in the Hindu. So now let's see what could be done. The early finalization of the memorandum of procedure. Now this was signed in the year 2016 between executive and judiciary, so as to have a guideline when it comes to the appointment. There can be a permanent independent body which can have members from the ministry, from the law ministry. It can have the eminent jurist. It can have members from the Supreme Court and High Court, and it can also have member from the bar. So this is how an independent body can be formed, and there can be a collaborative process between the executive and judiciary, so as to balance the power when it comes to the appointment of the judges, and none of the bodies are to be given the primacy when it comes to appointment of the judges. The Law Commission also pointed towards the ensuring balance of power here. Now let's see in short that what this memorandum of procedure was. Memorandum of procedure was, this was in the year 2016 that the guidelines for making appointment was given. It talks about the seniority and merit and plus integrity. Now these principles are to be followed when it comes to the appointment. There can be a written explanation. That means the reasons can be given in the public domain for the appointment, for removal and for transfer of the judges. However, the judiciary said that we cannot give reasons for the removal of a judge because it is going to affect the future perspective of the future career prospect of the concerned judge. The quota for the jurist, memorandum of procedure also talks about there can be member from the bar. It also said there can be committee for the appointment and also a separate secretariat so as to maintain the data and etc. and other things when it comes to the appointment. The rejection criteria was included, that is national security and larger public interest. However, the judiciary pointed out that these two are very vague and very vast criteria, so as to reject or appoint a person. In fact, the rejection criteria, it is going to be very vague. So that's how there is no current consensus on the memorandum of procedure, and still India follows the Collegium system. And we have discussed the problems with the Collegium system. We also discussed the article. So that's it for today. Thank you. Have a nice day.